court will now have to decide on the Gyan Vapi Mosque, where Hindu groups say a videographic survey has revealed the presence of a shivling. I'm Barkha, you're with the Mojo story. This is our big focus on the program today. We're looking at the escalating dispute around this place of worship in Varanasi. Remember, BJP supporters have always said that after Ayodhya, they would be targeting complexes in both Varanasi and Mathura. And today, the courts have been approached with a similar petition in Mathura as well. Now, looked at from a perspective of a law and legality, there is a guiding principle of the Places of Worship Act, which basically freezes all places of worship as they are on August 15, 1947, with the exception of where the Babri Masjid once stood. To understand how the Supreme Court might react, should react, we're joined by leading constitutional expert Faizan Mustafa. Let's go across now to Professor Mustafa, who has done a detailed analysis of this particular law that not many people of this generation would remember, it having come in the 1990s, in 1991 to be precise. Mustafa Saab, great to see you. Let me start by asking you, the very admission of the plea that the Supreme Court has taken and decided, at least for now, that where the structure that the Hindu group says the shivling should be enclosed and remain sealed off, and namaz should also be allowed. In this interim response by the Supreme Court, do you already see the Supreme Court now proceeding with this in contradiction to the Places of Worship Act? If you had to explain to our audience very simply, what is the Places of Worship Act, what would you say?
Thank you, Barkha. The whole point is that Supreme Court is yet to pronounce on the constitutionality of Places of Worship Act. There was a reference which Supreme Court on its own brought in the Babri Masjid judgment, to which a number of people have made a reference. Now, here the court, what it did, it issued notice to the Banaras administration and to the UP government. And it said, since it is being claimed to be shivling, let it be protected. And removed all the other conditions which the Banaras court had put on the Muslim parties in terms of number of people who can offer prayer and the use of this wazu khana, so to say. So I feel that there is nothing wrong in the Supreme Court order, but probably the civil court in Varanasi, in the light of 1991 Act, should not have entertained this petition with such speed. There was no survey report yet the court is saying that there is a shivling and therefore, we are putting XYZ restrictions on that. The Places of Worship Act, as Barkha, clearly says that whatever is the religious character of a place of worship on 15th August 1947, that cannot be changed now.
Sir, I'll just ask you to lean back a little. आपका थोड़ा सर कट रहा है, थोड़ा सा पीछे होके बैठिए आप. Yes, sir. Let me start by asking you, as a follow-up to what you've just said, that the BJP supporters and those who are supporting this movement to basically have a mandir at where the Gyan Vapi Mosque today stands, they say that there is an exception to the Places of Worship Act, and in that exception, the Supreme Court could find place to actually move forward with this demand.
I don't see that there is an exception, so to say, because what they are referring to, that act not to apply to Ram Janmabhoomi Masjid and nothing contained in this act shall apply to any place. I think this is not covering the Gyan Vapi Mosque, so to say. So this argument is not correct. And therefore, today I read somewhere that they are saying, well, we are not changing the character. In fact, it has always been a temple and we have been praying there. The same old plea which was taken in the Babri Masjid judgment as well, that they have been saying that it has been a temple all through. So court has to look at that question. But from the Supreme Court proceedings of yesterday, will be wrong to prejudge what the court is going to say. But I feel, Barkha, that the court may refer the matter to the Chief Justice of India and request him to constitute a constitution bench to pronounce on the constitutionality of 1991 Act. What has really happened that in Babri Masjid judgment, the court itself has held, in categorical terms, that the 1991 Act is in response to the positive obligation on the state to uphold the constitutional ideals of secularism. So, what the Supreme Court on its own has said that this law is consistent with the basic structure of the Constitution. Something which is consistent with the basic structure of the Constitution, to say today that it is contrary to the provisions of the Constitution would be extremely difficult. The argument which is being made from the other side is that it excludes judicial review. And I see that there is some merit in that argument, because Parliament through a law is saying that all disputes come to an end, and now whatever character is there in 1947, that is to be preserved. So that is the argument which is to be tested in a constitution bench, that whether it excludes judicial review. And if it excludes judicial review, then it will be unconstitutional.
So explain that. If the Supreme Court itself has quoted extensively and in a way sanctified the Places of Worship Act in its own judgment on Ayodhya, how can the constitutionality of it be under question? And this is a good time to remind the audience that there is a BJP leader of Delhi, Ashwini Upadhyay, the same leader who has demanded a new law on population control, the same leader who has been spotted at several rabble-rousing, hate-mongering meetings, who has gone to court, Professor Mustafa, there you see him, to challenge this Places of Worship Act. So how is this open for question again, and why?
The argument is like this, that in the Babri Masjid, this was not one of the issues before the Supreme Court. There was no arguments held in favor of the Places of Worship Act or against the Places of Worship Act. So these are just the passing observations. And if there are passing observations from the court, then in legal terms we call them obiter. Now, if it is obiter dicta, then it is not the law laid down by the Supreme Court. But a Supreme Court bench, again, which has already issued notice on the constitutionality of 1991 Act, has to hear arguments in favor of the Act and against the Act. The real problem, Barkha, is that in parliamentary democracy, government has to represent parliament in the court. And generally, there is a presumption of constitutionality of laws passed by the parliament. And it is the duty of the government to say that parliament has legitimately exercised its power. So now the government has to turn around, if it has to go with Ashwini Upadhyay's petition, and say that parliament was wrong in passing this law. And if parliament was wrong, then basically the parliament should either repeal the act or amend the act, rather than get it struck down by the Supreme Court.
Well, that was going to be my next question. Technically, there is nothing to stop Parliament from actually bringing the Places of Worship Act and amending it or scrapping it. The BJP has the majority. It can do this if it decides that it's politically worth its while. There's nothing that legally can stop this from happening, or is there?
Correct. There is nothing legally. There is no legal bar on them at all. They are free to amend it. And the court would also be free to scrap it if court finds, after the arguments, that it is in the teeth of basic structure or even the provisions of the Constitution.
So technically and hypothetically, the BJP could bring this law to Parliament, change it or read it down, and the Supreme Court would then have to decide whether that change is in violation of the basic structure of the Constitution.
I feel that the government would prefer that before they go to the parliament to amend it, court itself strikes it down. And court itself says that our observations in Babri Masjid judgment were obiter dicta.
From hearing you, it seems to me that you believe that this is what might well happen.
I think so. That's why, I feel, Barkha, that for better community relations or for protection of any place of worship, our over-reliance on some law will not help. ultimately law cannot protect any place of worship. And therefore, rather than relying on law, we should try to develop harmony between faiths. Unless there is a peace between religions, and within religions, there will not be the lasting peace in the world. So, both the communities, ideally of Banaras, because it is a local dispute, should sit together and reach an outside court solution. I feel, Barkha, that the kind of disputes we are having, it will be a good idea if at all places of worship, say if it is a mosque, we reserve one room or create one room where silent prayer by the by the followers of other religions can be permitted. Because the argument was simple: these five women, they want just to pray somewhere in that Gyanvapi mosque. So if we on our own create that silent zone at all places of worship for the followers of other religions, then probably there will be better, harmonious relationship between the communities, which for
That's a
me is
very
far more important.
That's a very interesting idea, but let me show you, as you've seen, the images of what is at dispute. The Hindu groups say that the survey has revealed what they say is the evidence of a shivling. The Muslim groups say that this is just part of a water fountain, the wuzur, as you said. अब इसको कौन resolve करेगा? ये आपस में बैठे भी तो इस पे कभी agreement होगी नहीं. So your suggestion is a very interesting suggestion, that places of worship which are contested or have contested narratives should have space for the other communities, and that could be one way forward. But this could not have been, for instance, a solution to Ayodhya. In the end, the court had to adjudicate.
No, in Ayodhya also, you would recall that there was a late attempt of arbitration, and I am told that the Muslim party was willing to concede, but either smelling a victory in the Supreme Court or the rigidity in the stand of other parties, the arbitration could not move forward. I had written in Indian Express when this arbitration thing was done that it will not work. It is too late for them. But in a matter like this, I think if they can sit across and they can create some space for the worship of, people from other religion who feel that this is their place of worship, it may work. Why I'm saying so? Because if you look at those paragraphs which are about 1991 Act, in the Babri Masjid judgment, the court itself says that historical wrongs cannot be corrected today, and we believe in the principle of non-retrogression. And ancient rulers may have committed many mistakes. So the current generation, of course, it can't be blamed for the wrongs of rulers of earlier centuries, but can take the initiative. Okay, maybe this was wrong, but we give you some space for your prayer. And if it can be silent prayer, there will be no conflict.
But here's the question to you. Disputes can never be, and settlements both can never be decontextualized from contemporary realities. And at a time when many members of the Muslim community feel that they are being marginalized as a voice of influence in how politics is shaped and formed, you may not have Muslim political leaders agreeing to this proposal that you have made at all. You have, for example, in Asaduddin Owaisi saying, we already lost one mosque, we're not prepared to lose another. Do you believe, that the Muslim groups should respond outside of the legal process to this dispute? Or do you believe that there has to be a simultaneous process both inside court and outside court?
You see, as a law teacher, if someone wants to use law, I can't be saying don't use, process of law. Yes. But I feel that outside the court settlement may give a lasting peace. In the Babri Masjid case, even Ali Mia, who was a reputed ulema, had written that the Babri Masjid Action Committee took a very rigid stand and it has harmed the cause of Muslims. So at a time when already it is being said that they are being marginalized or there is so much of hate against them in the society, I think they should come forward and learn from the Babri Masjid dispute. Ultimately, Babri dispute, not only polarize our society, but also, cause harm the interest of Muslims. So in the larger interest of Muslims, I think they should explore other options also, because ultimately that law on which they are banking does not give them, much of a guarantee that they will win, because law, as you agreed, can be amended or court itself may strike it down. So had the Muslim groups, say in 1992, after the demolition of Babri Mosque, had entered into some kind of negotiation. At one time, even Atal Bihari Vajpayee was willing to say that, okay, we will preserve the structure, but in the rest of the place, let a Ram temple come up. So that would have been a win-win situation. Or what the Lucknow court said, that it made 3 divisions of that plot. In the end, they lost everything. So I think that at times, buying the goodwill of fellow countrymen and showing large heartedness may help, but decision should not be taken by political leadership. It should be taken by the management committee locally and in consultation with the local petitioners.
So you're saying that if the local Muslim community of Varanasi and their representatives could negotiate an out-of-court settlement, that would be the lesson to learn from Ayodhya, where in the end, as you said, the Muslims were left with nothing. And you're saying that the same could happen here, because to bank on the Places of Worship Act is no security or no guarantee at all.
Yes, Barkha, and there is a difference between the two disputes. About the Babri Masjid, Barkha, historically speaking, it was never proved that there was a grand Ram temple which was demolished to construct the Babri Mosque. About the Gyanvapi Mosque, there is a historical evidence that it was partially demolished. It was a temple and a mosque was constructed. Therefore, in my opinion, the Gyanvapi case is weaker compared to Babri Masjid case, except that in Gyanvapi there has been some litigation and some settlements, and there is a proof of continuous prayer. So maybe you can make some arguments, but I believe interfaith relations and relations between religions can never be governed and settled through law. They are to be settled through goodwill.
Here's my last question to you. The fact is that even if Gyanvapi is negotiated and settled along the lines that you are suggesting, then uske baad Mathura, uske baad koi aur jagah. So every day, we are seeing a ridiculous debate around the Taj Mahal. You are seeing the Qutub Minar sought to be renamed. So where does this stop? A Muslim leader listening to you might turn around and say, okay, Faizan Saab, but it won't end here. What would you say to that? What is the solution for that?
That is the whole problem, because if you look at the Vishwa Hindu Parishad list, they have 3,000 mosques there. So there has to be some settlement, and give and take would be like this. Okay, A, B, C, D are yours, but rest we are conceding. So that's why I'm saying give and take need to happen between communities. Somebody suggested that Truth and Reconciliation Commission should have been there like South Africa. So what kind of Truth and Reconciliation Commission? So Bauds and Hindus, Vaishnavites and Shivites, and then Sikhs and Hindus post-independence, Muslims and Hindus post-independence. But something is to be done to settle these kinds of polarizing issue. After all, I am surprised, Barkha, that religion occupies such a central place in our society, which I think for a person like me is not a great sign. We are too religious, and this lately this religiosity is devoid of spirituality.
Yeah, I have to say I relate to what you've said. It's tragic to see religion being a point of division instead of a point of bringing people together. But I'm very, very struck, interestingly, by your suggestion, and I would agree with it, that the courts are not the route to these settlements, and people in the end, without politicians distorting or representing them, have to find a way to move ahead. Thank you, Professor Faizan Mustafa. Always enlightening to have you, and we'll have you back soon as the Supreme Court makes its position very clearer. Thank you very much, sir. Thank you. Take care.
Thank you.
It's great to see you here. Thank you for watching our work. If you haven't subscribed yet, don't forget to click the bell icon and subscribe to Mojo Story and support independent, robust journalists.